Coming on the air with some breaking news at the Supreme Court. The High Court has ruled that states do, in fact, have the authority to ban transgender athletes from taking part in girls' and women's school and college sports. This involves two separate cases, both brought by transgender women. It is expected to have wide-ranging implications. Let us bring in our senior legal correspondent, Laura Jarrett. I see that you have been sifting through the decision and the dissent for some time now. Top lines, what does this mean? The top line here, Craig, is that all of the states, 27, in fact, states that have tried to enact these types of bans, trying to make sure that girls' sports teams do not include transgender women and girls, both at the college level all the way down to lower school. Those bans can now stand. As you mentioned, Craig, this involves two different states, West Virginia and Idaho, but the implications are nationwide and far-reaching. The states here said that they had tried to enact these types of bans to protect women's sports, to keep women and girls safe, and also to ensure competition for women and girls sports. And today, the High Court, in a divided opinion, saying states can, in fact, do that without violating the Constitution, without violating federal law. They say here in part, Craig, in the majority opinion, separate sports teams for biological males and biological females are reasonable, given the inherent physical differences between the sexes. Allowing only biological females to play on women's and girls' sports teams can reduce the risk of physical injury and ensure fair competition. The court going on to say what's more, forcing women and girls to play against biological males can deter some women and girls who would otherwise participate in sports from doing so. They go on to explain further that the Equal Protection Clause allows schools to maintain separate teams for female and male athletes, and schools may do this to determine eligibility for women and girls sports teams based on biological sex. This is constitutionally justified. So again, this has to do with the states of West Virginia and Idaho, but it now means that all those other 27 states, Craig, that have tried to pass these types of bans that have been under some criticism and dispute, those bans should now be also upheld under the Constitution and under Title IX. 6-3 decision. The Title IX Equal Protection Clause. Did the majority answer both of those? Did they use both of those? They did, and they didn't have to. They could have just done this under one or the other, but they actually do tackle those, and they say the Constitution and Title IX do not require an overhaul of women's and girls' sports throughout America. Obviously, there is a heated dissent. Justice Sotomayor reading her dissent, impassioned dissent, I can imagine, from the bench right now, which is something commonly done in high-stakes cases like this. We see the dissent reading, again, right now, having to do with these two different cases.
We thank you for watching, and remember, stay updated on breaking news and top stories on the NBC News app or watch live on our YouTube channel.